with the Texas EcuSearch group. This information became a dispute as to whether it was actually disclosed or not. That really isn't relevant. However, what did come to our attention once we had found this individual, this is the same individual who feloniously recorded our investigator while speaking to his previous attorney, Mr. Kelly Sims. He, on December 13th, had sent an email to lead detectives Uri Melich and Sergeant John Allen stating that, "I believe the remains were moved after our search," end quote. Subsequent to us finding Mr. Jordan and that conversation, which we unfortunately do not have a copy of that was recorded, he had a conversation with law enforcement and did a complete 180 on his story as to whether he searched the area where the remains of Kaylee Marie Anthony were found. I also present at that statement were the prosecutors who were present in today's courtroom. Now, on December 8th, we took Mr. Jordan's deposition. During the process of trying to attempt any bias that Mr. Jordan may have or any further evidence that Mr. Jordan may have in reference to his searches with Texas EcuSearch, we asked him if he actually blogged on the internet about this case and about his searches. His response was yes. I then asked him, what topics did you blog about, or what did you say? His response is he could not recall. I asked him for, I guess there's a blogger name that people use to remain anonymous. I asked him specifically what those were that he utilized and which he gave us. We immediately went back to our office and began searching what little blogs that we're aware of that exist on this case. We found a significant amount of posts relating to Mr. Joe Jordan. It also came to our attention that he also ran a website, joejordan.com or josephsjordan.com. It also came to our attention by reviewing these blogs that he would post certain photographs of his searches on his website. Basically what he was doing was he would go to a blog and say, for I have one example here, I apologize, I can show counsel, where he states, for August 17th's photographs of today's search with Texas EcuSearch, go to joejordan.com. And we actually did go to joejordan.com, but subsequent to us finding this witness, he suddenly closed his website down. What we are attempting to find out is what was actually posted on the World Wide Web by Mr. Joe Jordan, any photographs that he's taken relating to this case, and the searches that he may or may not have taken part on. One other interesting side note for Your Honor to know is Mr. Jordan's name pops up throughout this case as a interesting individual who has on numerous occasions intentionally inserted himself with emails to law enforcement, directing them with tips, directing them with information about the Anthony family, directing them possible evidence about Miss Anthony, our client. And I think for a proper investigation as to this witness, any potential bias he may have or his credibility, we would like to be able to see what photographs he's in possession of, what he's actually posted on his website that he, for some reason, after we found him, decided he wanted to take down. And I think as part of our investigation, it requires us to look into those matters, which is why we filed a motion for subpoena de Castillo.
Okay, thank you. Mr. McLeod?
Thank you, Your Honor. Just briefly, Your Honor, Mr. Jordan was deposed by defense counsel. In fact, both defense counsels were present and asked questions of him during that 1-hour deposition. At no time did anybody ask him anything concerning any photographs that he had taken, any photographs that he had posted on any sort of website, anything relevant to any sort of media such as a photograph. in their motion, they're alleging that Mr. Jordan himself took this photograph and somehow they'd be entitled to the photograph because it's of Suburban Drive. Again, in the deposition, there was nothing asked in regards to what a photograph was taken of, where it was taken of, anything at all that would lend itself to have the court issue a subpoena Duces Tecum. As far as Mr. Jordan's blogging on any sort of blog site, he is simply a guy that has an opinion, and he's provided that opinion on the website. He is not listed by either side as an expert witness. I don't know that his opinion would matter because he hasn't been listed as such. I don't know that he's going to qualify as some sort of an expert where his opinion about evidence or what occurred in the case is ever going to be relevant. He is like anybody else who happened to answer or put something out on the internet in regards to this case, some person with speculation as to what occurred or what might not have occurred. It would seem to be harassment in an attempt to get Mr. Jordan to turn over every single blog he ever wrote during the year or so that he was answering these questions and or putting his opinion as to what was going on. What I would suggest to the court is their motion isn't sufficient legally to ask for the subpoena Duces Tecum. There's no evidence that Mr. Jordan took any photographs, is in possession of any photographs, has any relevant evidence to what the defense is seeking to garner. The same thing goes for his blogs on the web. They are simply his opinion. There's nothing relevant, there's nothing discoverable, there's nothing that's going to lead to anything admissible in court in regards to any opinion that Mr. Jordan had in regards to the Casey Anthony case.
Mr. Baez, reply.
Briefly, Your Honor. Well, the whole reason that we didn't ask him in depositions because we were unaware that photographs existed. It wasn't until we went and looked at the blogs under his blogging name that we were able to find that. And I can submit to the court as an exhibit.
Let me ask you this. On the blogs that you read, did Mr. Jordan specifically state that he had taken photographs of Suburban Drive where the body was located and the date and approximate time of those photographs? Or is it just people in the blogosphere just chit-chatting back and forth?
Here's the thing that I'm not sure if the court understands. There's thousands of blogs about this case, and unfortunately we don't have access to all of them. A lot of them you have to register for. There are numerous entries by that in the short time.
The point I'm trying to get at, Mr. Baez,
yes,
is in order. Mr. Jordan is a citizen, okay? And if law enforcement was attempting to get a search warrant, you would have to have some nexus and some thing that's called probable cause to invade that citizen's space. And I'm simply asking you, did he affirmatively say in a blog that he had taken pictures of Suburban Drive that has some relevancy to this case, i.e. the location where the remains were found, that would have some relevancy that would show that they were there or not there at the time and date in question? I'm trying to distinguish whether or not you're going on a general fishing expedition or whether or not there is something specific that can lead to the discovery of tangible evidence. I cannot give you a license to fish.
I am not asking for a license to fish. I can tell you we have a email to law enforcement, to the lead detective in this case, stating that he searched the area, there were no remains found. We have previous blogs from previous searches where he states that he has photographs and that you can go to his website of those searches. Furthermore, we have EcuSearch documents where he noted items that he found at the area.
Let's back up to the last statement you made. Does he say he has photographs, or does some unknown person say or claim that he has photographs?
Neither. Neither. I can tell you that he has photographs of other searches that we were able to find. Now, as to whether there are photographs out there that do exist, these are not private photographs that he had an intent to make private. I will add that these were public for the entire world to see. On top of that, he was advertising for people to come to his website. By going to these blogs and posting his link, it only became private and taken down once the defense found that he is a potential witness in this case.
You're not arguing that because someone decides to post something on the internet, then suddenly they are subject to having someone else come in and get a court order requiring that they produce it to someone?
No, what I'm arguing is I think that this witness has relevant information that he has posted on his website as to this case. I think it's clearly established by his email to law enforcement and his pattern of conduct that we've been able to uncover clearly in the short period of time that we've been able to research who he is and what information he has potentially.
In the deposition that you took of Mr. Jordan, specifically, is there anything contained in this deposition that you can point to that leads to the discoverability of relevant evidence?
Yes. He stated that he did search the area in very close proximity. Unfortunately, he doesn't know the exact spot of where Kaylee Marie Anthony's remains were found.
But you took his deposition and he said that.
Yes, he said he searched. He gave us the instructions of where he searched. He could not say, I searched where she was found because of the fact that he doesn't know exactly where she was found. From my knowledge of the case...
Did at the time that you took his deposition, I presume that you knew the location of where the remains were?
Yes, sir.
I also take it that you had aerial photographs of the area where the remains were found?
Yes, sir.
And during your deposition, did you show him aerial photographs of that area and asked him to show you where he searched?
We asked him to point out where he searched, yes.
And did he point out in the magic area?
In the general vicinity.
When you say general vicinity, what do you mean?
I would say within 20, 30 feet. I will also add that in the Texas SecuSearch documents, he refers to items that were eventually seized by law enforcement and entered into evidence in this case. That tells me this person was extremely close. And I think considering the fact that he has been an interested individual from July of 2008 all the way on till today, that especially posting, from what we've seen so far, photographs of his prior searches, that there is a very strong possibility, at least a reasonable argument, that he potentially does have evidence that would be useful to the defense.
And what evidence is that?
I'm sorry?
What evidence is that?
Possible photographs of where he actually searched. There's an issue as to whether...
And did you ask him at the time that you took his deposition whether or not he had photographs of this area where the body was found?
No, because we were unaware of that. We were completely unaware of whether he had actual photographs, because it wasn't until we went to the blogs and were able to determine that he was advertising that he has photographs on his website.
Going back to the blogs, Mr. Baez, did he specifically say in a blog that he took photographs of the area where the body was found?
No. And I would say that, I would add to that we do not have the total sum of all of his blogs. We just were able to get a short number of them. Many of them get taken down, just like he took his website down. I'm sure he could also delete certain things from the blogs. This individual has changed his story already. He has committed a felony in recording our own investigator. He has done things intentionally to thwart the investigation of the defense.
Judge, I'm going to object. There's absolutely no basis for that comment whatsoever.
I think there is. I think it's a clear argument that can be made.
All I'm interested in is a factual basis for the court to issue a subpoena Duces Tecum. All I'm trying to find out is what is the basis in fact that this court has to order blogs and what you requested in this for the court to order that. And that's all I'm trying to find out. I'm not interested in all these collateral matters, because these collateral matters don't have anything to do with a basis for the issuance of a subpoena Duces Tecum that he may have lied or may even have committed a felony.
I will tell you what we have is that we have specifically a direction, an email that he sent to law enforcement indicating that he searched there. We have EcuSearch records that he searched there, in addition to noting items that were seized in evidence in this case. We also have other blogs that show that he has taken photographs and put them on his website. And the only way that we're able to see if this happened, if he actually has photographs, is to get a subpoena Duces Tecum. If I work for the state attorney's office, I can issue an investigative subpoena like that and get what I need. But unfortunately, we have to go through the court as defense, and this is what we have to do.
And also, the subject of the investigative subpoena could file a motion to quash it. And then the state would be required to come in and establish some probable cause for the issuance of the investigative subpoena.
They could, but certainly Mr. Jordan appears to wish to cooperate with the state attorney's office, where he certainly, by his counsel's presence here today, doesn't wish to cooperate with the defense.
There's no reason to put me in the middle of somehow I'm thwarting the defense.
I said nothing of the kind. Nothing of the kind. And
Anything else, Mr. Baez?
I'm sorry?
Anything else, sir?
Nothing further.
Okay. Mr. McClellan, anything else you would like to?
Your Honor, there is no factual basis in which the court should grant this motion for subpoena Duces Tecum. They haven't established anything in regards to any sort of photographs, anything to do with Mr. Jordan's photographs and/or relevance to their case.
Okay. The motion for application of subpoena Duces Tecum will be denied without prejudice, to be renewed if there are some facts that would justify the court issuing the order. Mr. Ashton, since you're here, did you supply Mr. Baez a copy of your affidavit?
I did. It should, I believe it was mailed yesterday. I don't know if he's received it yet, but we did supply a copy of it.
Okay.
We also came over in case the court wanted to discuss the scheduling of the expert report. I know Mr. Baez sent an email with a suggestion of 20 days. We have some sort of alternate suggestions today. I don't know if you want to address that now or not.
Might as well, because I'm going to get that order finished sometime today.
That's what we thought.
Your Honor, I'm done, may I be excused?
You may be excused, Mr.
Thank you, Your
McClellan.
Honor. The suggestion that we received through email, that I assume went to your JA as well, was that all the expert reports could be done within 20 days. While we don't have a problem with, we understand that that might be the case to certain experts. For instance, Dr. Lee, we can certainly understand why he would need 20 days. What we request from the court is, rather than setting one date so that we get deluged with 11 reports in one day, that be more staggered than that. And the one that we are most concerned about is Dr. Furton, who is indicated as being an expert on the cadaver dog issue. Our hope is that the court will be able to have time to hear the cadaver dog issue and maybe the suppression issues in early February. If we don't get his report until the 23rd of January, obviously that's not enough time. So, particularly with reference to him, we would ask that we have if he can, an earlier date. Some of these other experts we've looked at, for instance, Dr. Spitz, we would assume that that's a fairly easy report to do. He's a forensic pathologist. Some of the others I would think would be a little easier. So I would just ask that we, if possible, sort of adjust the time based on the necessity of the individual expert, rather than just say 20 days for everything, and then we get 11 reports at once. I will comment that obviously we already have a report from Dr. Bach and Dr. Huntington during his deposition, which was started and not finished, indicated he would have a report for us, I think, sometime next week. So, we've already arranged a couple of them, but we would suggest a more staggered approach if possible, based on the necessities of the individual expert and report.
Mr. Baez, Mr. Mason?
We have papers that we will be filing shortly in reference to these issues. There's anything more than I can say. Some of the concerns, there are multiple issues that come up as a result of this. For example, the first one that comes to mind is we're asking experts to rush together, put a report together. When, as the court has acknowledged, that we're not required to do so, but now we are. So then they run into the issue of the state holding up a piece of paper and saying, this is all you're able to put together as a report in cross-examination. So that amongst several other issues that we've uncovered, research that we're in the process of doing. I put together the 20, I asked for that specific date because Your Honor asked that I give you an answer by Wednesday, 12 p.m. So I've already been turned down on 30. That's why I requested the 20.
Mr. Ashton, anything?
I don't know what the mysterious papers are. Perhaps we could get a clue rather than a 445 filing, so we can kind of all plan for the rest of this case. But obviously,
I would have hoped that the two sides would have gotten together and worked out a schedule. As I've indicated to both sides, I have no problem in setting schedules. And I have previously indicated to you that my time frame of my schedule is a whole lot different than what your schedule would come out to be. And I can go back in my office after I finish a couple of things I have on my desk dealing with probate and guardianship, which should take me about an hour. And then I can start on this. And I can tell you that it will be something that y'all will not like, because I believe there are 7 days in the week.
Yes, I'm happy to discuss with counsel some sort of a staggered schedule based on the necessity of the individual doctor. I know I pointed out Dr. Lee because my last work was he was in Croatia, so I assume and his work is more complex. I understand that. But I'm willing to talk about it and suggest some more.
All I'm going to say is that at 3 o'clock this afternoon, I will be sitting at my desk, formulating the order and putting timelines in it. And I would like your input, but I do not need your input. You know what your work schedules of your experts are and what they are capable of doing. As I said before, these folks came in, they examined evidence. I would be surprised that after they examined evidence, they didn't have opinions. When people look at things, examine things, and they're expert witnesses, they come to conclusions and opinions. Now, and they write notes, because we all write notes to document what they've seen. And it's a matter of taking those rough notes that they do during their examinations and taking those rough notes and translating those into reports. Because they deal with more than one case. And